Hello, everyone, and welcome to our latest edition of our 1515 video podcast. I'm Chris Capewell. I'm a partner and the global head of the regulatory team here at the Maples Group. Joining me today, as you can see, are my colleagues Anthony.mourginos, who we refer to as Don, and then laura.goucke, who we refer to as Laura. Please note the contents of today's video should not be regarded as legal advice, and they should be taken as a general update only. If you are listening from your usual podcast app, you'll find any resources documents, including a high-level copy of some of our presentation slides and the speaker info. Donnie, I think over to you if we can initially, if you can track everyone through for a few minutes at least, just on beneficial ownership and particularly of the new recent amendments brought in through the Beneficial Ownership Transparency Amendment Act 2025. Thanks, Donnie.
Yeah, thanks, Chris. A few things to update for beneficial ownership. Two main things. So as Chris mentioned, we have the new Beneficial Ownership Transparency Amendment Act, and that made some key amendments to the existing Act and regulations. So I'll tick through some of the changes that we've had. First of all, and quite a welcome change, there was a really key amendment to the definition of beneficial owner, in particular as it relates to a trustee and trust and how they're supposed to be captured under the definition. The change really clarifies that when you do have a trust or a trustee in the structure, and that trust would meet one of the limbs of the definition of beneficial owner, you have to name that trustee as a contact person for the legal person. So not a beneficial owner, but rather a contact person. So a similar category that we find ourselves for senior managing officials, but it's where the trust itself or the trustee in that capacity would meet one of the limbs. A correlated change, they clarified that in circumstances where you do name a senior managing official, and just by way of reminder, that's in circumstances where we don't have an identified individual or relevant legal entity identified as a beneficial owner, or indeed where we don't have a trust or a trustee identified as a contact person. It's in those circumstances that we name a senior managing official. So it extended out the categories of entities that could be named so that you don't name a senior managing official. So that's a welcome change as well. Another change related to the alternative route to compliance as it relates to registered mutual funds and private funds. Previously, there was some doubt in the legislation as to who exactly had the responsibility for complying with the alternative route where the registrar were to seek information from the legal person. The change that we have now really clarifies the position that it is the legal person, so the fund in this circumstance, who has the responsibility for ensuring that the named contact person, whether that is the administrator or another adequately licensed or registered Cayman Islands vehicle, who is named as the contact person, the fund itself bears that responsibility. And that tracks through with one of the corresponding changes made to the regulations, where the regulations insert a specific administrative penalty for the fund itself or for the legal person for a failure to respond to a request from the registrar. Another change, and it kind of interacts with the next aspect of the amendment to the regime generally, but relates to access to the register or public access. One of the provisions in the Act relates to what information specifically can be sought by a member of the public who is seeking access to the information. Now, the list of items or information that you can get access to if you are a member of the public, it doesn't match up exactly with everything that you provide to your corporate service provider when you are filing for the beneficial ownership regime. There's a more limited list. So what the change does, it clarified that for individuals, there is a slightly limited list, and it clarified that when we refer to individuals, we refer to not only individual beneficial owners, but also senior managing officials. So previously, there was a bit of doubt as to whether or not senior managing officials' information would necessarily be open to the public there. So now we have clarity, they definitely will.
Donnie, just on the point that you mentioned there about the contact information for the senior managing official and whether or not that would be made public, I guess that's a good segue into the access regulations themselves. I think they were turned on 28th of February. So do you want to just give us an overview of where they're at the moment? And I guess I think we covered it on one of the earlier podcasts, just a broad overview of some of the key points.
Yeah, sure. So yeah, that's right. The legitimate interest access regulations it came live on the 28th of February. So basically, they set out a framework for certain members of the public to apply to the competent authority, so to the registrar effectively, to request access to the beneficial ownership information on a particular legal person. They interact with and come at almost the same time as the beneficial ownership transparency access restriction regulations, which are broadly kind of the polar opposite. They provide for a framework for individuals and people who are named on the register to apply to the competent authority to restrict access to their information that's on the register. So just ticking through both of those. So the legitimate interest access, who are we talking about? So who can apply as a member of the public to get access to the information? So it's basically three categories. A person engaged in journalism or bona fide academic research, a person acting on behalf of a civil society organization whose purpose includes the prevention of basically money laundering and the associated offenses, or a person who's seeking that information in the context of a potential business relationship or a transaction with the specific legal person that we are making a request for. So those are three categories, but the key part is that if you are making that request, you have to have a legitimate interest in that information for the purpose of preventing, detecting, investigating, combating, or prosecuting money laundering or any of the associated offenses. So quite a broad list, but very specific to the overarching goal of the beneficial ownership regime, which is preventing money laundering associated offenses. And then, as I mentioned, just quickly, by way of reminder, we do have live now the access restriction regulations. So that provides a framework for individuals to apply to the competent authority to restrict the information that is on the register. It's a fairly narrow pool of people or reasons why that you could apply for restriction. So limited to individuals or individuals living with the related applicants, where they are at serious risk of kidnapping, extortion, violence, intimidation, or similar danger or serious harm. So quite a high bar. There's an application process to go through as well. It requires engagement and discussion with the regulator and submission of many materials. The process would include a fairly closed loop system where you can upload what will likely be quite sensitive materials.
I should just add for completeness that this isn't unique to Cayman, right? It's that we're actually reviewing consultations and regulations for other jurisdictions, particularly on the legitimate interest, US as well with the Corporate Transparency Act. So it's an international initiative that's happening across the globe. And related to that, Laura, I guess another focus internationally is not just on the technical laws, but also the enforcement of those laws. And Cayman in particular was focusing on that following the FATF review. So did you want to talk about some stuff that you've been seeing, I guess, with the Tax Information Authority, particularly around enforcement?
There have been some really interesting developments over the last week or so. As you probably know, the Tax Information Authority, the TIA, through the Department for International Tax Cooperation, is responsible for all of the Cayman Islands frameworks for international tax cooperation, including the Common Reporting Standard, or CRS. This week, the TIA has begun issuing penalty notices to Cayman reporting financial institutions in respect of breaches of the CRS regulations. In particular, we've seen two particular types of penalties that have been levied. One for failing to file a CRS return or a nil return that is due on the 31st of July of each calendar year, and also for failing to file a CRS compliance form, which is due on the 15th of September of each calendar year. And just to give a bit of background, the penalties that we are seeing relate to breach notices that were issued by the TIA in or around October of last year. And those breach notices required the FIs to both remediate the identified breaches and invited FIs to make written submissions setting out the reasons why the penalties ought not to be imposed. And what we have seen is that in most cases, despite the fact that the remediation steps had been taken and the written submissions had been considered, the TIA has taken the view that the breach of the CRS regulations has occurred and went ahead and imposed a penalty for those breaches that were identified. Although we did see that the TIA did reduce the amount of the penalty from what was originally proposed in the breach notices. And this really just does serve as an important reminder to all our Cayman reporting FIs to pay close attention to those CRS reporting dates and to please reach out to our team if you require any assistance in meeting those obligations, because we're happy to help.
Thanks, Laura. Great. I guess one question I would have, if some of our clients are receiving these notices and they want to dispute them, is there a way that they can do that?
Yeah, well, it's spot on, Chris. We're receiving a lot of questions about that and whether there is a possibility to appeal. Pursuant to the CRS regulations, there is a right to appeal to the Grand Court of the Cayman Islands, and this must be done within 60 days of receiving the penalty notice. In order to succeed with such an appeal, a Cayman FI would need to show that the TIA made an error of fact or law, or it failed to properly consider and apply the required statutory criteria when deciding to impose a penalty or the amount of the penalty, or other standard judicial review grounds that you see, for example, illegality, irrationality, procedural unfairness, or legitimate expectation. So if there are any Cayman reporting FIs that have received a penalty notice and do require further advice about those appeal rights, we are happy to assist.
Perfect. Excellent. Thanks, Laura. Donnie, back over to you, if I can, just on virtual assets. I know there were some amendments coming through dealing with custodians and trading platforms. So do you want to just give us a quick overview of that? And then I think we can close.
Yeah. Important update. As of 1 April of this year, we will have the VASP licensing regime now open, or will be open, for virtual asset trading platforms and virtual asset custodians. So previously, although there was provision in the Act for licensing such entities, we did not yet have a live licensing regime. So that will go live on 1 April. So that's good news. Along with that update, CIMA have released a updated rule and statement of guidance, which will commence on the same date, on 1 April, which will apply to licensees, virtual asset trading platforms, and virtual asset custodians. That includes a lot of the common things that I'm sure our listeners will be aware of as it relates to regulated CIMA licensees, relating to corporate governance, conduct of business, other prudential requirements, IT and cybersecurity, and things like that. So all should be fairly familiar requirements, and also a welcome change. So, and then a few other important notes just to highlight here as it relates to all VASP entities, not just the licensees that will be capable of being licensees as of 1 April. The first one is all VASP registered persons and licensees will now need to have 3 directors as opposed to what was previously 2. And at least one of those directors does need to be an independent. So that's an important change, in particular for existing registered persons. Number 2, all VASPs need to seek CIMA's prior approval for any changes to their business plans. So quite a common requirement that applies across other licensee regimes. The VASP must also notify CIMA of any litigation related to its business within 30 days of that coming to light. Any VASP that is holding fiat currency on behalf of clients does need to do that and hold that currency in a regulated bank. So that's a key and important change. And there is also clarification of a new offense, or introduction of a new offense for VASPs who make or permit misleading representations about their virtual asset service activities. So a specific offense for those VASPs. And that's it.
Cool. And I'm assuming if people have questions on virtual assets, they can contact you.
Absolutely.
Awesome. Okay, everyone, thanks for listening and or watching. Donnie and Laura, thank you very much for taking the time. I appreciate you both, and we look forward to seeing everybody next month. Thank you.